business leader. So we started corporate governance, discuss about corporate governance course, discuss about board committees. We have discussed about role of non-executive director, role of chairman, role of CEO. We have discussed about directors remuneration. We have discussed about shareholder activism and institutional investors intervention. We have differentiated between AGM and EGM. So let's move towards further topics of corporate governance. So there is a topic called corporate governance approaches. Corporate governance approaches. What does that mean? Corporate governance codes are defined by using two approaches. I mean, there are two ways according to which corporate governance codes can be defined and complied with. What are two approaches? Rule-based approach and principle-based approach. Rule-based approach and principle-based approach. What is the rule-based approach? There are some codes that company need to follow, and they are compulsory, like law they need to follow. I mean, this is a legislative approach. And there are rules that company need to follow. If they will not follow, they will be penalized. There will be penalties. There will be fines. There will be strict action companies need to face. Means strict or legislative approach of corporate governance that is called rule-based approach. What is principle-based approach? There are rules that company need to follow. But in any case, if company is unable to follow, they can provide explanation, justification why they haven't followed, and that explanation, that justification will be acceptable. I mean, this is a lenient or flexible approach. I mean, there are corporate governance codes that you need to follow, but if you are unable to follow, you can explain or justify, and that explanation, justification will be acceptable if it is appropriate. That's why it is also called comply or explain approach. Comply or explain approach means there are certain rules that you need to comply. But in case of non-compliance, you can make non-compliance by providing explanation, meaning justification. In some countries, there is a rule-based approach, but they are very few. So mainly rule-based approach is where it is in USA. While in UK and some other part of the world, there is a compliance of principle-based approach. So we have covered UK combined codes of corporate governance, mean UK stock exchange codes, UK combined codes of corporate governance, mean UK stock exchange codes, that is principle-based approach. According to UK combined code, chairman, CEO should be separate person. But suppose there is one person who is working as a chairman as well as CEO, company can do like that, but they need to explain, they need to justify why you are not having separate person. So company might be provide justification. We are in search of a chairman. As soon as we find, we will separate them. Our company is in early stage, they cannot bear the cost of two separate person. So that's why company is holding one person as for two positions. While in the USA, the USA Stock Exchange, that is called SEC, Security Exchange Commission of USA, and their corporate governance codes name as Sarbanes-Oxley. Mean USA Stock Exchange corporate governance codes name as Sarbanes-Oxley Act. UK Stock Exchange codes named as UK Combined Codes on Corporate Governance. USA Stock Exchange codes name is Sarbanes-Oxley Act. And those companies who are operating in USA are operating under SEC USA. They have to follow Sarbanes-Oxley Act. Sarbanes-Oxley Act is what? Rule-based strict legislative approach. I mean, there are rules that you must follow. If you are not following, there will be fines, penalties, serious action you need to face. No explanation, no justification is acceptable. I mean, USA Stock Exchange codes is strictly compliant, while in UK, these are flexibility. There are flexibility, like company can follow or company even can deviate from some of the rules. So there are two approaches of corporate governance, principle-based approach and rule-based approach. What are the characteristics of rule-based approach? Prescribed set of requirement mean there is a requirement that you need to follow that they have defined. Quick way of ensuring compliance mean through this you can check who is complying, who is not complying. While in UK, principle based, everybody is complying, whether they are following two codes, whether they are following 10 codes, if they have provided explanation about other codes. So everybody is following, but in a rule-based approach, you can easily perform check of compliance. Adopts a checklist approach means there is a list that they need to follow. Clear distinction between compliance and non-compliance. Easy to see that entity is complying, and reduction of flexibility on the part of management and auditors mean there is no flexibility. Difficult to set rules to cover all situations, but there is a problem. While setting strict rules, it is difficult to set rules for all type of organization. In for large organization, the list of rules might be easy to comply, but for small organization might be it is will be considered as a burden for them. And possible to misinterpret rules. And if there are strict rules, no flexibility, no leniency, then if any company is not following, there are chances of corruption. I mean, to take a good report in favor of the company, they might be moving towards bribery to others so that they can get good report. And same rules apply to all, whatever their size. I mean, larger company can afford complying with strict legislative approach, but smaller company could be burden for them because to comply rules, company need to bear some cost as well. So there are some benefits as well as there are some problems. I mean, these are the benefits and these are the problems. Again, for principle-based approach, there are some benefits and problems. Activities of entities must address major principles set out in codes of best practices. Mean company can adopt according to their circumstances how many rules they can follow easily. Not simply a box ticking exercise. In rule-based, but you need to tick, 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 follow without considering why this code is. But in principle-based, if you are not following any code, you need to provide justification, explanation. Management will use their brain. What could be the acceptable justification, explanation? I mean, there is some self-learning as well. I mean, why this code is there? If we are not complying, what should be proper justification? More difficult to avoid than a rule-based approach. I mean, here company at least follow something. Easy to see that entity is complying. Not that much easy. I don't think so. This is a point here because this we can see in rule-based rather than principle-based. Directors required to work in the entity's best interest, and directors will see about what code we need to bear the cost and we need to follow. And those codes, if complying with those codes, company need to bear more cost, they can avoid. More flexible and therefore better able to deal with the new situation. In according to situation, they can adopt. Easier justification for apparent breach of principle, and company can provide proper justification in case of breach. But principles may be interpreted differently, but companies can adopt codes differently. So there are some arguments in favor of rule-based approach. In rule-based approach, there is clarity. for the company what they need to follow. I mean, there is no deviation, there is no non-compliance. In our companies, standardization can be achieved. I mean, everybody will be complying at the same level, not like principle based. One company is following 5 codes, other is following 10 codes, other following 50 codes, other following 2 codes. So there is no standardization. Binding requirement, the criminal nature make it very clear that the rule must be explained. Mean you need to follow everything. But there are some problems with the rule-based approach. Mean argument against exploitation of loopholes. Mean there could be chances of loopholes in rule-based approach. Mean chances of bribery, corruption. If company is not following, but they need to show we are following, so they will bribe the inspector, like please write a report in favor of us. Underlying belief, the belief is that you must only play by the rules set. There is no suggestions that should want to play the role. Mean there is no self-learn. Flexibility is lost. This is like a checklist approach without recognizing, without understanding why this code is. So there are some benefit, clarity, standardization, binding requirement. There are some problem, exploitation of loophole, mean chances of loopholes, flexibility is lost, and checklist approach. And company might need to bear legal cost as well. Because to comply with any of the rules, company need to bear some cost that could be burden for small companies especially. And the advantages of rule-based approach are disadvantages of principle-based. I mean, there is no clarity in principle-based. There is no standardization. There is no binding requirement. And the disadvantages of rule-based are advantages of principle-based. Mean in principle-based, there are less chances of loopholes. There is more self-learning. There is flexibility. And company can adopt rules according to their circumstances, mean they can allocate cost accordingly. So we have covered, there are two approaches of corporate governance, principle-based approach and rule-based approach. What are the benefits or advantages or arguments in favor of rule-based, and what are the arguments against rule-based approach? Principle-based approach is UK combined codes of corporate governance. UK combined codes of corporate governance name how in a UK in the past there were different reports issued. Like there was a report called Higgs report. There was a report called Cadbury report. And there were some other reports were issued. In every report, there were some new codes. There were some new codes. What they did, they combined all the codes of all the reports issued, and they named it UK combined codes of governance. So this we have discussed so far. The corporate governance we have discussed till now, that is UK combined code of corporate governance, mean principle-based approach. Now we are moving towards the rule-based approach, mean what is the Sarbanes-Oxley Act? So we are moving towards Sarbanes-Oxley Act. The Sarbanes-Oxley Act is a rule-based approach that was defined in 2002 after the Enron case. Because Enron was based in USA. So after Enron scandal, USA Stock Exchange defined strict legislative approach called Sarbanes-Oxley Act, and according to this, company need to follow something compulsory. And those companies who are operating under SEC, mean registered with SEC, are those companies who are operating in any part of the world, but their parent company is registered under SEC USA, they need to follow Sarbanes-Oxley Act. What are the key points of Sarbanes-Oxley Act that company must to follow? Auditor independence mean to maintain independence of the auditor. In Sarbanes-Oxley, it is defined if auditor auditing any of the company, they cannot provide any additional services, mean they cannot provide any other services. They can only provide audit services to a client. If they want to provide other services, they need to resign from the audit. An auditor cannot perform other services than audit to one company, one client. Audit partner, every 5 years, audit partner must be rotated off the audit. Mean a partner can continuously conduct audit of a company, but for maximum 5 years. After 5 years, audit firm need to change the partner to maintain auditor independence, because in Enron case, auditor were also involved in the fraud. Restriction on dealing, directors cannot deal in company shares. They cannot buy, sell company shares when in sensitive time. Sensitive time is a time immediately before issuing financial statements and immediately after issuing financial statements. Because this is the time where there are major fluctuations in share price. So directors can trade in company shares. They can buy, sell company shares, but not in sensitive time. Because what happened in Enron case, director bought the company shares before issuing financial statements at lower price, and they made the fraud. So that through strong financial statements picture, through high share price, they can sell those shares at high price. So that's why now, according to Sarbanes-Oxley, directors are prohibited to deal in shares in sensitive times. Increased financial disclosure, company need to provide more detailed disclosure regarding off balance sheet financing. Off balance sheet financing term is mainly relating to leases. If company have obtained leases, they need to provide detailed disclosure in the financial statement. Because what happened in Enron case, company bought some asset on leases. If you bought some asset on leases, you need to show the asset as well as liability. They showed the asset, but eliminate the liability of $7 billion. So that's why, according to Sarbanes-Oxley Act, company need to provide more detailed disclosure regarding off balance sheet financing. Accuracy of financial statements. According to Sarbanes-Oxley Act, financial statements accuracy is depend upon company's CEO and CFO, Chief Executive Officer and Chief Financial Officer. They need to make sure company producing accurate financial statement. And if company once have issued financial statements, after that it is found there are some errors, mean company is moving towards issue revised financial statements. In that case, these two persons have to pay back their last 12 months bonuses. Those are based on previous results. So that's why company financial statements accuracy must be vouched by company CEO and CFO. And in case of financial statements are going to be revised, their last 12 months bonuses should be called back. Internal control report, not export, it's a report. In annual reports, we saw there were some mandatory disclosure, financial statement, chairman, CEO statement, committee's statement, governor's statement, any other business. According to Sarbanes-Oxley Act, in annual reports, company need to provide one more compulsory disclosure, and that is a report on internal controls. In how you are managing your internal control, how you have performed review of internal control, what weaknesses you have found in the internal control, and how you're gonna overcome those weaknesses in future. It is a mandatory disclosure. Company need to provide report on internal control system. And audit committee is must for the company. Company cannot start a trade until they have established their audit committee. If they haven't established audit committee, they cannot start a trade. So these are the rules that a company must to follow if they are operating under SEC USA. Auditor cannot provide other services to audit client. Engagement partners should be rotated of the audit every 5 years. Directors cannot deal in shares in sensitive time. Company need to provide more detailed disclosure regarding off-balance sheet financing. And financial statements accuracy depends upon company CEO and CFO. And if financial statements need to be revised because previous are having errors, these two persons have to pay back their past 12 months bonuses. Company need to provide a report on internal control system as a mandatory disclosure in annual report. And company cannot start a trade until they have established an audit committee. I mean, these are the compulsory things that company need to follow according to Sarbanes-Oxley Act if you are registered under SEC USA.
So if there's any inaccuracy in financial statements, is there any amount specified?
If financial statements prove wrong after issuance,
Okay.
they need to pay back their past 12 months bonuses.
Okay.
I mean, they are responsible for that. That's why they need to make sure before issuing financial statements, they are accurate. There are some key effects of SOX. What are the key effects of SOX? Personal liability of directors for mismanagement and criminal punishment. Mean to control the behavior of directors, especially if they cannot deal in shares in sensitive time. They need to make sure accuracy of financial statements. Improved communication of material issues to shareholders, especially detailed disclosure regarding off-balance sheet financing and report on internal control system as well. Improved investor and public confidence in corporate USA, obviously by providing more disclosure, this will improve the confidence of public on companies. Improved internal control. Obviously, if company need to provide a report on internal control, company will establish a strong internal control system. And external audit will be performed more quality because they will be independent because they are not